You, Cathaoirleach, and I welcome the opportunity to speak on this important piece of legislation. Minister, at the outset, I want to reference correspondence that I received from constituents in relation to the Irish Council for Civil Liberties correspondence regarding this legislation, and they have raised three particular points. One, that the scheme should be expanded to all survivors, and this threshold of the 6 months needs to be looked at. Secondly, that the legal waiver should be removed that has been criticised by the UN, which has specifically asked for its removal. And thirdly, to increase the compensation that's available. And I want to focus on that third aspect, Minister. I want to focus my contribution on the provisions that are missing from this particular piece of legislation. And that is in relation to the vaccine trials and the failure by GlaxoSmithKline, or GSK, the current corporate successor to Wellcome, which carried out many of these vaccine trials in our mother and baby homes across our country. I believe that GSK, which is the successor to those responsible for carrying out the vaccine trials on toddlers in our mother and baby homes, must stand up and must be held accountable. Where we do not, at this stage, we won't get answers. We must have an acknowledgement from GSK that what was done was completely unethical, and as a result, at the very least, they should and must contribute to this redress scheme. And Minister, as you know, there were at least 13 vaccine trials carried out on more than 43,000 children, according to the Commission of Investigation. And more than 1,000 of these children were in the institutions concerned. So survivors who were used literally as human guinea pigs in vaccine trials in the mother and baby homes must receive an apology from GSK and must have this acknowledged by the company by making an offer of compensation for practices that would not have been tolerated in the United Kingdom, where the company was based at that time. While the Mother and Baby Home Commission of Investigation reviewed the medical records available to it, and I repeat, the records that were available to it, it concluded that there was no evidence of injury to the children involved in the vaccine trials. I believe, Minister, that this conclusion was simplistic. These children were treated little more than human pincushions by the companies and the clinicians involved due to the large number of injections that they received and blood samples that were taken. How can any of us be sure that there was no delayed immunological impacts from these formulations? Particularly if no guardian was able to tell a subsequent doctor treating the child that he or she had previously received an experimental vaccine formulation. The child, as an adult, would not be able to inform his or her treating doctor that he or she was involved in an experimental trial. Each of these children should be contacted, should have been contacted, should be contacted now, provided with their medical records, and these records, combined with their subsequent medical history, should be independently reviewed and a full and transparent report published on the conclusion of these assessments. Only then can we honestly claim that there is no evidence of injury to the children involved in these vaccine trials. And at a very minimum, this must now happen, and this must be provided for in the legislation, and the full cost must be borne by GSK. Minister, the Mother and Baby Homes Commission of Investigation report did, however, flag the issue of consent and the failure to secure it. Now, why is the issue of consent so important? It's primarily because we all, each and every one of us, have a basic human right to our own bodily integrity. There is a need for informed consent in advance of any medical procedure or medical trial. And while those particular processes and procedures were far looser in terms of the definition of medical consent in the era of these trials, the basic fact is that consent was not sought, despite it being the legal and regulatory requirement at that time. Without engaging with the parents or guardians of the children, a clinician could not deem them to be suitable for inclusion in any trial. For example, paragraph 34.121 of the Commission report on the 1968 to 1969 measles vaccine trial states that the trial should have excluded children with, and I quote, with a personal history of convulsions or allergy, asthma or eczema, or a strong family history of same. Now, Minister, without consent, how could any of the clinicians have ascertained this in respect of those children in the mother and baby homes? And even at that time, consent was a standard procedure for vaccinations outside of clinical trials, at least in some of the mother and baby homes. For example, paragraph 34.71 states, the Dunboyne Institute records contain completed written consent forms relating to instances where infants resident there were presented for immunisation at the public health clinic. These consent forms were signed by either the mother or the matron. However, there were no consent forms available for the clinical trials. And it's also clear from the Commission's report that the Department of Health itself had serious problems with the use of children in these homes for clinical trials, like concerns that were raised in the UK. However, paragraph 34.92 states, a Department of Health document dated the 13th of December 1963 dealing with this application noted that in April of 1962 Professor Meenan had asked for a field trial on an oral polio vaccine in Pelletstown. In that instance, it was noted that the Department of Health had no objection to the trial itself, but raised concerns regarding the selection of Pelletstown. And they quoted, while the procedure proposed appeared to be a safe one, the selection of a group to participate was open to objection and approval was not given on that occasion. The department did not want clinical trials carried out on children in homes. However, that didn't seem to make any difference to the clinicians involved, whether the department gave consent or not. Indeed, paragraph 34.163 notes that permission was sought for a field trial, an oral polio vaccine on the children in Pelletstown and was refused. The report goes on to state the Commission takes the view that there was a high probability that Pelletstown was in fact used in the trial despite the refusal of the Department of Health. And GSK have many questions to answer. Why did the scientific publications on the UK and the Nigerian trials specifically refer to consent? Yet these references were conveniently left out of the same publications on the trials based on Irish children. Why was Ireland seen as a soft option for trials involving children in institutions? Clearly, such trials could not take place in the UK. And that was also the case in Ireland, based on the regulatory and legal system that was in place at that time. However, because of the lack of enforcement in Ireland, GSK was happy to proceed, despite clearly knowing that there was no consent, as reflected in peer-reviewed academic journals which had to have secured the authorisation from GSK's predecessors before publication. It's also important to highlight at this point that these scientific publications were peer-reviewed in advance of publication. In the British Medical Journal and in the Lancet, the academic publications of the British trials included an outline of the consent and confirmation that consent was obtained in line with law and ethical standards. However, this was not the case, as I say, in relation to the publication of the Irish trials. Why was this not set as a precondition of publication? Because it should have been. And if it had been, and the academics were told that they must provide that, maybe then these children would not have been exploited and those institutions would not have been used again and again and again and again for trials. This culture of cover-up went from the academic journals right up to the highest echelons in this state. The attitude was one to brush the problem under the carpet and it would go away. Paragraph 34.153 in the Commission report states that the Department of Health had flagged it in 1968 that Professor Meenan had conducted vaccine trials without the authorisation of the Minister, and yet nothing was done. And when it comes to mother and baby homes, it wasn't just the state, but reputable drug companies, reputable academics, and even reputable academic journals such as the British Medical Journal and the Lancet that were all prepared to turn a blind eye to the basic human rights of these children purely because there were institutions, purely because there were institutions in Ireland, and purely because those institutions were not being properly regulated and monitored by the state. There was a blatant policy of just ignoring consent where it couldn't be obtained. Paragraph 34.122 of the Commission report states, on the 5th of September 1968, Dr. Coffey told Dr. Burland from Glaxo Laboratories that she had come up against the usual complications while trying to arrange a field trial of Glaxo's measles vaccine in Dublin. The response from Glaxo was extremely interesting, according to the Commission report. Dr. Burland advised Dr. Coffey to liaise with Dr. Hillary, as she may be able to suggest a way in which you could overcome the problems that you have encountered. In other words, you could get a way around the law of the land and the refusal of the Department of Health to actually sanction this particular trial. There was a clear culture within the company which has today morphed into GSK to circumvent the consent process. And let us not forget that there was a clear benefit not just to GSK but also to the clinicians who participated in those trials. The Commission report itself references direct financial payments. And at the very least, funding was provided to research facilities which would assist those researchers in securing scientific publications. These, of course, went a long way along with the scientific publications of the trials themselves, which were facilitated by ignoring the basic ethical consent for vaccine trials. And all of these scientific publications, the ones directly involving the trials, the ones where funding was provided both indirectly and directly by the predecessors of GSK, ensured that these particular academics had scientific publications to their name, which secured them promotions and financial benefits as a result of that, as well as increased status within the scientific community itself. And of course, this was also of benefit to the universities involved, namely University College Dublin and Trinity College Dublin, who benefited indirectly by using these children, vulnerable children, as guinea pigs without any consent. Minister, GSK needs to clarify why these experimental vaccine formulations were not placed on the market on a commercial basis. Was it, and I'd like to know, was it because they were not effective at preventing the diseases that they were supposed to? And if that was the case, it would have impacted on the subsequent immunity of the children involved in these studies. Were the children outside of homes, either in Ireland or in the UK, subjected to the same battery of needles that the children in the homes were? There was multiple administrations of vaccine doses and multiple blood sampling procedures. And I doubt very, very much, Minister, that any child outside of those institutions, either here in Ireland or in the United Kingdom, was forced into being used as human pincushions on a regular basis to the benefit of the clinicians, to the benefit of their institutions, and to the benefit of GSK. That company benefited financially from this research. It was happy enough to ensure that those trials were conducted without consent, that they benefited from it, and they now need to live up to their responsibilities to these children and to their families. Guramahagot.